To speak on behalf of the... Sorry?
Albany? Is that the way it's pronounced?
Albany?
Depends on where you're from.
Yeah. Depends on where you're from.
Depends on where you're from. We say Albany.
Over that before.
But, again, I had some... I had on the agenda the opportunity for folks to come and speak before Gaptel came up and had a chance to present. Is there anybody that's dying to come up and present for 5 minutes and talk? I'd like to go ahead and get Mr. Donaldson going. We might have some folks that want to talk near the end of the session. With that being said, I'd like to call the meeting back into order after lunch. Again, Mr. Donaldson, I appreciate you guys providing lunch for us today as well. And with no further ado, I'd like to turn it over to you.
Thank you, Chairman. Pardon? Turn it on? Yeah, I think it may be on. First of all, I was very glad to follow Bob this morning. I wasn't sure what I was going to talk about when I came, and he gave us an awful lot to discuss, and your questions and his answers. I wanted to address something I really didn't plan to address early on, and that's the issue of expungement. And I think it's going to be very important in this context. It's very important in the context of what you already have in the law. And I want to address a young man by the name of Steve Donaldson, my son, who's 30 years of age, who's in the finance business in Atlanta and is right successful. And he's a smart young man. When he was 18, he was much smarter. He knew everything there was to know, as most 18-year-olds do. And he got caught up in one of these situations where a number of young men in college were taken down to the police station, and some were arrested and some were turned loose. And he, knowing everything there was to know, didn't realize that he was one to be turned loose until he ran his mouth, saying to the officer, "My daddy's a criminal defense lawyer and he'll have your badge." He was arrested for obstruction of an officer. Now, I went to Statesboro and met with the prosecutor and the judge, and we wrote an appropriate letter of apology, and the charges were dropped, and that was an appropriate disposition, and I was not at all offended that they kept him overnight in jail. He went on and got his bachelor's and master's degree in finance, and then applied to become a stockbroker. He's in the federal data bank for an arrest for obstruction of an officer. I had the record expunged. He went to work with another company, which is common in that industry, and I had to go back and get it expunged again. It's still there. And until and unless expungement means something, and it doesn't, in my experience, mean anything at all. I mean, you can have an order of an expungement, but then that's in the record that it was expunged. Then it really is a meaningless exercise. He's been able, because he's got a daddy who is a lawyer, to get court orders each time that he wanted to be like other people. And most of us in college, when we were 18, knew everything we knew there was to know as it was. I mean, had I been in that situation and had my daddy been a lawyer, I probably would have said the same thing. So I think that's an important issue, and the research that I did was not as current as Mr. Keller's, because at the time I did mine and the materials I looked at, there were only 4 states, California, Louisiana, Texas, and Virginia, who tested DNA on arrest. And I understand there is a new statute, and as I understand the way the statute works is that the federal data bank will accept DNA data from any lawfully obtained source, whether it's misdemeanor, felony, or otherwise. Of course, it has not been decided what is lawful. The issue has not gone beyond local courts. And by local, I mean some state jurisdictions have addressed the question of whether it's appropriate to take a sample on arrest. It seems to me that the argument generally raised to support that is that it's no more intrusive than fingerprints, and that fingerprints have traditionally been taken for the purposes of identity, and that when you are arrested, when there's probable cause to arrest you, whether you're Steve Donaldson or not, that you give up some expectation of privacy, and that's the key words when we're dealing with this issue. The problem is it's the privacy in your identity. And one thing that I found interesting, someone here may know differently than me, but I tried to find if the Supreme Court of the United States had ever addressed the question of whether it was an invasion of privacy to take your fingerprints. And the U.S. Supreme Court has not addressed it. I don't think anyone would seriously contest the issue, because when someone is arrested, they may get out on bond. They may not get out on bond, but there's a government interest in making sure that the person that they're taking to trial is the same person that got arrested. And so I don't think anyone would seriously argue that fingerprints should not be taken on arrest. But once you've taken the fingerprints, you've done the identity. You have this person identified. You're not gaining anything by taking a DNA sample. You're not getting any more identity than you already had with the fingerprint. What you're doing is creating an additional basis on which this person can be investigated for the possibility of having committed some other crime, which is not appropriate. You know, I guess if you take it to, because you see, you're innocent until proved guilty. Your rights as a citizen, when you are arrested, are marginally impacted because there's a governmental necessity. If there is probable cause to believe I've committed a crime, then I need to be taken in and either make bond or not, but be answerable. But beyond whatever's necessary to make me answerable to the offense, there's no need to take other private information. Our Bill of Rights, the Fourth Amendment, and the first 10 amendments exist because the framers of the Constitution did not trust the government they just created. They retained rights that they were not going to give to government. To put blind faith in government, with no offense to you gentlemen, is a foolish thing to do. I mean, we need to retain individual rights. We do not need to be in a posture where we trust you to make all of our personal decisions. We need to be in a position to say, you can't have my DNA until I have given up all of my civil rights. And that's the position I think I came to argue here, is that what's the big deal waiting until there's a conviction? What have you lost by waiting until someone is convicted? You know, if you need DNA prior to conviction, if there's probable cause to believe that I've committed some other crime on which there is some or DNA available at the crime scene, you can get, based on probable cause, a judge to sign a warrant to take my DNA. There's no useful purpose for DNA unless there's no useful purpose in taking DNA from someone who's simply been arrested for some offense. Based on you just want to have it done. You know, in 65, I think, in Davis versus Mississippi, in Meridian, Mississippi, there was a rape. The victim identified her rapist, the perpetrator, as a young black man. They arrested 75 young black men solely for the purpose of getting fingerprints, until they found the one that was there. And they did find the person. They had a fingerprint there. Now, that's not, there were 74 people there whose rights were seriously violated and whose fingerprints are now, I guess, still on record someplace. They were arrested pretextually. How many people are going to be arrested? And, this goes back to not trusting the government. How many people are going to be arrested so that you can get DNA? You know, just because I'm a little bit suspicious that this fella may be a pervert or something of that nature. You know, we don't need to just pass feel-good legislation, and we've got a lot of feel-good legislation. Just this past week or the week before, Tom Murphy, former district attorney in DeKalb County, wrote an op-ed in the Atlanta Journal-Constitution attacking the recent legislation, or the legislation that has the 1,000-foot perimeter. You can't have sex offenders within 1,000 feet. Well, nobody thinks that sexual predator is not going to go 1,001 feet if he's going to be a sexual predator. It's feel-good legislation. And what you've done is you've caused perverts to lose their jobs. So now you got unemployed perverts going, who create an even greater threat. You got to think your way through what you're doing with that kind of legislation. Sounds real wonderful. We don't want them within 1,000 feet of our children. Well, you can't do that. You can't keep them from going to church. So according to Mr. Morgan, and I didn't think I'd ever be quoting the district attorney of DeKalb County as a source, but he says the guy can still go to church with your children, sit in the next pew with your children, scope your children out, but he just can't live or work within 1,000 feet of them. It's crazy. Yes, when I start talking, I don't listen, and so our position at GADCL is that there should be no DNA sampling until there is a conviction. And if you look at Justice Scalia's recent opinion in the U.S. Supreme Court, I forget the case, but it's a concurring opinion. He believes that no one is arrested that isn't guilty. I think he's quotes some statistics that we can take issue with, but you're going to end up getting all of the DNA if he's right anyway. You're going to wait until there's a conviction. And that's the criteria, that's the constitutional hurdle. Yeah, we've got a statute, and 7 apparently now, there were 4 states that say you can take it on arrest, but that's untested. And somebody's got to come and look at the court and say, this man, my son, who was arrested for mouthing off at a police officer, has given up his DNA forever into some data bank. It's not going to get expunged. Don't kid yourself about that. And why should you have to petition if you're acquitted to get an expungement? And why should you have to go to the district attorney who prosecuted you and lost the case? I've tried probably 200 felony cases over the years. I have yet to meet a district attorney, and I've won several of them, a lot of them. I've yet to meet a district attorney look me in the eye and say, I never really thought your client was guilty. I prosecuted him just for the exercise because I heard you could try a case. They don't do that. Hopefully they believe my clients are guilty. Hopefully they're not prosecuting a man for any reason other than belief in the guilt of my client. Well, once he's been acquitted and it's up to him to decide whether to expunge the record, that's not realistic. We don't have enough DAs like Bob who don't have some personal ego involved. We don't trust our government, and we shouldn't trust our government. We have no obligation to give up all of our rights to our government. Hopefully we elect people who are who we want in those seats, but we don't have any guarantee. And so we have some rights that we hold dear and that we should not give up. Government gains very little by testing on arrest. And especially if you look at the fact that you're going to have to, as all 4 of the states that I had looked at, and I suspect the other 3 as well, have an expungement procedure on acquittal or upon dismissal. But why should anybody have to go through that? Why don't you just wait until you're convicted and take the DNA and then run the case?
I have a question for you, and I'm going to ask you to share your opinion in a minute, and it'll be just your opinion if you choose to share it. But
sure.
Or maybe you can enlighten me through some factual means. But I'm hearing you say that, I just want to restate what I think I've heard, is that, as we discussed earlier, photograph, fingerprint identifies the person definitively.
Sure.
Fingerprint is an indelible biological marker.
Absolutely.
So to take the next step to go to collect DNA under the name of identification, in effect becomes a unlawful Fourth Amendment search. Is that what you're suggesting?
That's what I say. And the Supreme Court hadn't agreed with me on many things, and I think they may agree with me on that. there is a governmental interest, a legitimate governmental interest in identifying the person that's arrested. No one's going to quarrel with that. But that governmental interest is satisfied with the fingerprint. That interest disappears once it's been satisfied. There's no need at that point to collect DNA evidence to accomplish what arguably you already have. I don't know that anybody is going to say that fingerprints aren't reliable. And if they are not reliable, if DNA is more reliable than fingerprints, then let's get rid of fingerprints and just do DNA. No one's going to argue that position. They want both, and it feels good to say, we're going to collect things from arrestees. We're going to make ourselves. There's no difference between a person who's arrested and presumed innocent until proved guilty than there is to my grandbaby that was born earlier this year. It's just simply go ahead and collect DNA on birth, and then we get into all sorts of questions about biblical references and mark of the beast and things of that nature. So I don't think we want to go there. I don't think we want everybody's DNA, but there's no reason to draw a line between someone who is innocent until proved guilty and my grandchild. Either you take the DNA or you don't before conviction. But if you're going to take it before conviction, then take everybody's.
Let me make sure I understand something you had said in there. It's on. Your opposition is for that you're stating is taking the DNA for identification purposes on arrest. But did I understand you say that if it's for investigative purposes, where there has been probable cause established, then you're not opposed to the
well, the law is clear about that. You go, if you think this man that you've arrested has committed some other crime unrelated to the crime that's here, but you have probable cause to believe it, and at that other crime scene there is some DNA, not many judges in this state that won't sign a warrant authorizing you to do the search to take the DNA sample, and that's as it should be.
Or even related to the crime that you were arrested
or related
for.
To the crime that you were arrested for. I mean, I was trying to take it to a broader context. If you have probable cause to get DNA, then you can get a search warrant.
I thought you had said that. Yeah. I just wanted to clarify that.
So our position and my position is that the state really loses nothing by waiting until conviction. Now, conviction for what? Those are policy decisions you guys have got to make. Do you need DNA from someone who's committed a nonviolent crime? If you've got somebody who's embezzled money and has committed that felony, is there any probability that person's also a sexual deviant or doing? That's a policy decision for you guys to make. You want to do it across the board for all felonies, fine. There is some question about misdemeanors in my mind, and that's not as easy a line to draw for me. When you and of course you guys are the ones who define what's a misdemeanor and what's a felony. You're the ones who are entrusted with that. What punishment you're going to dole out for what offense. There was, and it changes. That line changes from time to time. When I started practicing law, if you had any marijuana, it was a felony. Now you can have up to an ounce, and it's a misdemeanor. And so, but there is a big distinction between being convicted of a felony and being convicted of a misdemeanor. And you're convicted of a misdemeanor, you can still vote, you can still run for public office, you still can possess a firearm. You don't give up your civil rights, and that's the biggest difference. To me, the biggest difference is you retain civil rights. You don't lose that. And if you want to, and I think you probably have the authority to decide how much in terms of civil rights people convicted of misdemeanors are going to have to give up, and it would seem to me that there would be some misdemeanors for which you would want on conviction to collect DNA. Violent crimes. There are some sexual offenses that are misdemeanors. That type of thing. That's for you guys to decide. That's not my call. I don't think that's a constitutional issue. Because you make that decision. That's a legislative issue. But to me, it's a constitutional issue if you're going to take DNA from someone who has not been convicted. And I think that's essentially our position.
I have a question for you, if I could.
Sure.
It strays from DNA, but it gets to the question of, what some would call an unlawful Fourth Amendment search, and I look at it, I talk in terms of photo. I don't mean just booking somebody when they're arrested, but and we'll address this some in our next meeting in September. But I wanted to get your thoughts on it. Is using photographs to use photometric identifiers to identify, for example, in a sports stadium. Would it be an unlawful? Could you make a defense as a defense attorney if someone were arrested entering a sports stadium during a Georgia football game? I won't use Georgia. Let's say the Georgia Dome during a professional football game, bowl game or something, that was scanning folks as they were coming through the entrance and comparing each person one versus a subset of N, some million faces they had on some scan. They were trying to track down a known terrorist or try to track down somebody who was wanted, and someone was triggered on, hey, this guy right there, that's him, he matches this name in the database the folks were looking for, and an arrest were made. Is walking into a public place like that and having a photograph taken, would that, in your mind, fall into the category of unlawful search, or is that just
to have your photograph taken? I don't think so. I don't think that's an unlawful search. I mean, could I make a defense as a defense attorney? I probably could come up with something, but I don't think that it would be a successful defense. Bob Keller talked about reasonable expectation of privacy. I mean, when I walk the streets of Atlanta, when I go to a sports event, my face is, I assume my face is uncovered. If my face is uncovered, I have no reasonable expectation in whether I'm recognized or not recognized. And in my mind, the technology you use to recognize me is just fair game. If I'm worried about it, then I ought to wear sunglasses, and then I might have some expectation. You might have a problem if you have somebody go up and rip the sunglasses off of me, and then you take a picture. But no, I don't have an issue with that. Now, I assume that you would have some basis on which to compare that photograph with some known terrorist photograph or whoever it is you're after. But no, I don't think that the Constitution would prohibit that.
Just the question, just the thought I had, and you could answer this question, is there any constitutional measure about frisking, for lack of a better term?
Yeah, it's Terry versus Ohio, and there's some interesting material that I did look up. 2004 case. And I'll just leave this with you. It's Hibel, Hiibel versus 6th Judicial District Court of Nevada. And in Nevada, they had a statute that has been tested in various versions constitutionally about whether you have to give up, whether you have to tell a police officer who you are. If he has a legitimate reason to stop you, and there are, the magic word is not probable cause, it's articulable suspicion. If there is a reason to stop you and he can explain that to a judge, he can do a momentary detention, and that's not an arrest. There have been several attempts to make it so, and there probably is some legitimate state interest in knowing who the person is that you stop. In California, it was struck down. They had a statute, I believe it was California, I may be wrong, that said that you had to produce credible identification as to who you are. Well, I mean, there's no constitutional requirement to carry a driver's license with you, and the Supreme Court struck that down. Nevada, in the Hibel, and I may have mispronounced the case, basically says that there is if he has a reason to stop you and ask you who you are, you have to tell him who you are. And you see, you've got a threshold there. It's the articulable suspicion. It is, if you can't, the officer can't walk up and down the street and just ask everybody their name. But if there's a reason to ask him his name, then under this statute, of course, you'd have to pass a statute to that effect. And I'll just, I'll hand up a copy of that decision. The key there, and there's some language that I bolded in that case, and it has to do with there needs to be. Let's see if I've written it down. in the context of a Terry stop, that's the Terry versus Ohio. You can insist, constitutionally, you can insist on information from the person that was stopped, but it must be, quote, reasonably related in scope to the circumstances which justified the initial stop. If you have a Terry stop, and lawyers use those kinds of terms, and I'm sure the GBI uses the same kind of term, just a momentary detention, you can ask for information that is related to the reason that you stopped them. But if you want to go ask for questions, what kind of car do you drive, things that are unrelated to that, and you're just on a fishing expedition, then the citizen doesn't have to give up that information. And if there is no articulable suspicion, if there's no reason to stop, then the citizen doesn't have to give up any information. The line was drawn by the Supreme Court when California, I think it was California, I don't want to blame them for everything that goes wrong in the world, but
that's fine.
They had a statute under which they said you had to present credible verification of who you are. Well, what's that? And what if you don't have anything other than you just walking along in your bathing suit on the beach? It's just giving up information about who you are is I'm Pete Donaldson. That ought to be sufficient. There are, much of what I was prepared to say is not. Bob Keller I was very pleasantly surprised when he presented the district attorney's position here about, they're not trying to create Big Brother. Most of us in the defense bar think that the prosecutors want Big Brother. But I can say that the the 2003 position statement goes a lot farther than Bob Keller does. And they've got some criteria about which they want stop on test on arrest. They want
Mr. Donaldson, if you could, and to your point, if you could outline some of those concerns, and again, I share your regard for Mr. Bob Keller and his organization, but again, we're concerned. We want to make sure that we're looking at and are aware of all the voices out there. I'd ask early that you take an advocacy position. And as part of that, if you could kind of point to some of the voices that are out there, maybe not in Georgia, but maybe in other places or in the federal level, that we need to consider as we look at this.
Well,
I appreciate that.
Our current administration is pressing legislation like it was passed earlier this year. Now, they don't dictate in that legislation what kind of information can be obtained. Apparently, and I stand to be corrected about that because I haven't read the legislation, but my understanding is that it's is it CODIS, the database that they have, will accept any information that is lawfully obtained, and that whether if it's lawfully obtained from an arrestee as opposed to a convictee and that type of thing. I think it still remains to be seen whether you can lawfully take a DNA sample from someone absent probable cause. If you have probable cause, then you can do it. But absent probable cause, I don't think that there's I don't think it's settled at all that you can take a DNA sample from an arrestee or a mere arrestee. Bob Barr, I read some of the material that he has put out, and he says, aside from the obvious argument that if you arrest a person, photograph them, and take their fingerprints, you already have information sufficient to identify them, and do not really need all the additional information gleaned from DNA sample. Consider the vast universe of persons who would be subject to this intrusive requirement under the Kyle Green legislation if it becomes law, and it may well have, I think that's the statute that became law, and Representative Barr, former Representative Barr, was very concerned about civil liberties, and civil liberties ought not be a partisan issue. Privacy ought not be a partisan issue. Law enforcement ought not be a partisan issue. We're criminal defense lawyers, but we're not trying to make the streets unsafe. We're not. I'm not here to tell you I want everybody turned loose from prison. I don't. I live in a neighborhood. I don't want crime in my neighborhood. I don't want people who are violent on the streets any more than anyone else does. But I don't want people put in jail and convicted with anything less than the standard of proof required. I forget the name, Calvin Johnson case is an example. And so DNA is a very, very powerful tool, no question about that. I won't argue with my brothers from the GBI when they come here and they say what can be done. The question is not what can be done with DNA, it's what should be done with DNA. I read a piece, a fellow, there was a poet, an American poet, by the name of, I think I've got his name here, Stephen Vincent Benet, in 1935 published something called A Litany to Dictatorship, and he and I've got a copy of it if you want it, but it's a really moving piece, and he's addressing pre-World War II Hitler in Germany. And he talks some in the first person and some in the second person. And at one point, he has a line I really like. He says, "We thought because we had power that we had wisdom." Power and wisdom are not synonymous. Wisdom and knowledge are not synonymous. Yes, DNA can do an awful lot. The question that we need to answer here is, what should it do? What should we be able to do? We can create a database, as I suggested earlier, with every living human being born in the United States, and that you would have an incredibly powerful tool to sort out and make a decision. I would suggest to you that that's every bit as constitutional as testing on arrest. I would suggest to you that you shouldn't do either, that it would become a very dangerous practice, that we would be moving toward the big brother that Bob graciously said the district attorneys don't want.
Let me ask you a question that either your opinion or knowledge that you had, a question I had asked Bob earlier was dealing with the ownership of information.
Well, it's a great question. It really is a great question. Do I own my face when I take it out on the street? I think that to the extent I show it to you, I don't own it. Do I own my DNA? I think I do own it, and I think for you to take it, you have to have a reason to take it. Do I own my fingerprint? I do. But if you arrest me, you've demonstrated a reason to take it. If you arrest me, you have not demonstrated a reason to take my DNA. If you arrest me and suspect that I committed a crime and you have DNA evidence, then you probably can, through the auspices of a judge and a search warrant, get that DNA, and then it belongs to you. There's a line to be crossed, and what your job is, as I understand this committee, is to decide where to draw that line. DNA it's hugely powerful, but it's not wise. It's a science, and you have to exercise the wisdom to make the decision where to put it.
Got a question for you. Well, we've got you, Mr. Donaldson, again. One thing I'd like you to comment on is, and I know it's well established, but trying to understand, and this goes back years, I'm sure, but for purposes of identification, as we talked about before, taking a photograph, taking a fingerprint upon arrest, but the practice of running that against a database that could then hook me and link me into other crimes that were committed where fingerprints were lifted but no one was charged and convicted. That link, which goes beyond identification to using that identification mechanism for evidentiary purposes, could you speak to the constitutionality and how that was established and how that evolved?
That's exactly the reason that I tried to find if the United States Supreme Court had addressed the constitutionality of that. And I did a database search. There's that word database. I punched in the word fingerprint. In all cases, the United States has only been about 55 cases. The U.S. Supreme Court has used the word fingerprint. And none of those cases have they raised the issue of whether it's appropriate to do exactly what you've suggested. I think there are some state Supreme Courts that have done it and some federal courts of appeals that have. it's such a universal practice. The first time it appears in the U.S. Supreme Court is about 1935, I think, and it was a case where some mobster was trying to hide his fingerprints. You know, it totally unrelated to the issue here. I think the issue becomes moot, Chairman, because it is so ingrained and so accepted, and I don't think anyone would raise the issue of whether it's appropriate to do that. And that does raise the issue when it comes to DNA. I think the argument, if I was the prosecutor and some lawyer wanted to challenge the right to do what you're saying, is that as long as the state lawfully comes in possession of that, and it now owns that fingerprint, that it can do what it jolly well pleases with it in checking other cases. And I think that's what, if I were a prosecutor, I would argue, and if I were the defense attorney in that issue, I really couldn't raise a whole lot of objection to that, primarily because it has been and is so ingrained in what we do. The photograph just as well. I mean, and again, with photograph, I have no problem, because that's just what you look like, and that's what you look like on the street. So I think there's a quantum difference between this new technology and the old technology. That you have established identity with the photograph and with the fingerprint, and to the extent it's a legitimate inquiry, you've done that, and there's nothing additional in that scope of legitimate inquiry that you can gain through a DNA search. You can gain a lot of information. But it's no longer in the scope of legitimate inquiry through the DNA. Yes, ma'am.
Just playing the devil's advocate, but I mean, there was a time period when all we had was to look at the person, and then photographs were developed, and then we learned how to fingerprint. And as technology has moved forward, we now have the ability, because I mean, to identify us as people. You know, first it was just you have to look at me. The next is, okay, photograph, and so forth. And now we have this new technology.
Maybe the DNA folks can speak to that, but I don't know what do you gain from DNA in terms of identifying a person that you don't already have from a fingerprint. The district attorney's position, and I can't believe they'd really say this, forensic DNA testing is no more invasive than fingerprinting, yet produces even more accurate results. You know, when you say it produces more accurate results, then they've been telling us that fingerprints are foolproof. It's the gold standard. No two fingerprints are alike. Are they now telling us that there's something more accurate than foolproof? I don't see what you gain with it. And once that governmental interest of identifying the arrestee has been satisfied, then you don't gain anything legitimate. You may gain a lot of information about me when you arrest me. And then that gets into, I got frightened when I listened to some of the things I hadn't even thought about that Bob addressed earlier today about exchanging information in databases. And it's kind of interesting. I was watching Bill O'Reilly, and some criminal defense lawyers will actually watch Bill O'Reilly. There are not many of us, but they were arguing. They were arguing about this recent wiretap stuff that the president has done, and it's not a government position. Someone who was arguing for the government, but I don't want to say it's a George Bush position, looked and said, the reason we don't go to judges is because we historically are terrible at keeping secrets. That terrified me. That really, really frightened me to think, if that's an administrative position, and I don't suggest that it is, that the administration doesn't trust the judiciary to keep a secret as to what kind of investigation is going on. The more people who know, the more dangerous it is. Well, if you can't keep that secret, then how are you going to keep my DNA secret? How are you not going to share that biological information about me? And then you guys are going to be looking in the civil context that is really frightening. And, what insurance company is going to get my DNA? Can they demand, when I apply for insurance, that I give a DNA sample voluntarily? It's a free world. You can contract. We won't contract to give you insurance if you don't give us a DNA sample, and we go see whether you got all these markers. that's frightening, and I'm really not prepared to speak to that today. But that's something you guys have got to speak to.
Come back in September.
Yeah, I mean that really is frightening to me, because the other element where you can collect DNA and do whatever you will is when you have consent. You know, and there's a whole body of law, that HIPAA law, that you give information that is protected and you have a reasonable expectation, and there's lots of legislation and litigation about your medical information. But if I say to my insurance company, okay, you can take a DNA sample, and they write a policy based on that, and then they share it with another insurance company, and then they share it with someone else, I hadn't even thought about that riding up here. And when I heard that, I don't envy you your job. I've got some pretty strong opinions, but they're not based on any research. They're just on gut, which is the same thing that I think you guys have probably got.
I have a quick question. This is a question to educate me, and I'm sure the folks from GBI will be able to educate us more on DNA. But when it comes to fingerprint, to actually use a fingerprint to identify someone, that fingerprint had to have already been taken at some point, correct? To identify
identify in relation to a crime.
Well, no, just to identify that this person is that person.
Yes.
Okay,
Yeah.
there had to be some starting point, either at birth or in my case when I entered the military, or got my security clearance, that my fingerprint was taken, identified with my name. So they're comparing that pattern of my finger to some existing record already to identify me, correct?
I think we may be on different pages. When I'm arrested,
Right.
this is the way I understand identification. I've been arrested. They take my photograph, they take my fingerprint. That's the starting point.
Okay.
They're identifying me. If I get out
Your
on,
association to that finger.
Yeah, I get out on bond and find somebody that looks like me,
Right.
and get a few folks to say that's Pete Donaldson. You go arrest him, and the guy doesn't know jack.
Okay.
You know, and he does look like me. You know, they've got no basis on which to compare, and
Okay.
and that's what I understand. The identity, the legitimate function of identity.
That was wanting to clarify the
Yeah.
identification, because with
Yeah.
the DNA, obviously they don't have any starting point already. So
Yeah.
okay.
I do have a question for you. It's stepping away from DNA, though, so before I go there, do any other members of the committee want to address any more DNA questions to Mr. Donaldson?
I've got one other point I want to make,
Please
and
go ahead.
that has to do with destruction of samples.
Okay.
And the only thing, and I really don't think I need to make too big a point or be too strident in it, because it really wasn't raised earlier. And that's a question of how long do you keep samples from a crime scene? The district attorneys, the National District Attorneys Association wants the ability to destroy samples from a crime scene. Calvin Johnson is free today and innocent today because Bob Keller, I suspect, was being a little bit humble with you, but he had enough sense to not have that DNA from the crime scene destroyed. And you know, I think it was 20 years, and he was proved beyond a reasonable doubt to have not been the perpetrator. You know, if we have this great data storage capacity that the GBI can speak to, there's no reason to ever destroy the DNA from a crime scene. There is within the prosecutorial committee a move afoot to say, and there are statutes around to say, you know, if you don't prove your innocence within a certain amount of time, then tough. You just have to be in prison the rest of your life, because we want finality. And Bob Barr spoke to that in some of his papers, and I'll find it in a minute. He agrees that there must be a high degree of finality to our criminal justice system for it to have the credibility essential to protect society and secure the rights of the accused. That being said, he says, and recognizing that we're not addressing those minority of cases in which the integrity of the prosecutorial process is drawn into question, such cases should and must be dealt with. A moral system of justice must never be so blind or inflexible that it refuses to admit error. And there are, just as there are cases where DNA will solve the case 20 years after the fact, and someone accused of murder is found to have been the murderer 20 years after the fact, there should be no provision that says we get rid of crime scene DNA, because it just might be that DNA might free Calvin Johnson. The Innocence Project, and I don't know the exact number, but it was over 160 people that have been freed from, I think, death row.
Mm-hmm.
You know, that's kind of scary. That 160 people have gone to death row and have been later proved not guilty. And the next question, and that begs the question, and I won't get into death penalty questions here because I've got an opinion that probably doesn't agree with a number of others. How many people have gone the next step beyond death row? How many people are 6 feet under because a DNA sample wasn't available? You know, some. You know, there are a few. I would agree with Justice Scalia that the vast majority of people arrested are guilty, and he takes that. But you see, the vast majority of people admit their guilt. It's the cases where people contest their guilt. It's the cases where people say, I didn't do it, that we need to be vigilant in. If a man admits to a crime, then you don't need DNA. You don't need it. Well, I guess with John Benet Ramsey you do now, but as a general rule, folks don't admit to crimes they didn't commit. You're looking at maybe 5%, probably less than that, of cases that are actually contested in the criminal justice system. And if you want to look at those statistics, then the system works reasonably well. But if you were to assume that maybe 5% contest, and half of those, only 2.5% are not guilty, but it's 50% of those where it's contested. I don't know if those are accurate statistics. You know, I have a lot of clients who tell me they're not guilty that I begin to suspect after a while. But and I have contested a few cases that I wasn't sure of, and I've contested some that I was very sure of and lost, and that's a bad deal. Yes, ma'am.
I have a question, because I'm not a lawyer. I just get to play one in the legislature, I'm a judiciary, which is...
It's not a bad thing to not be a
Oh, I
lawyer.
don't know about that. But anyway, now that we have DNA, is it being used enough that we can move forward and say pretty much as we go forward in the cases, we're less likely to have those mistakes on death row? Or is it used that much?
You know, I don't, well, I'm sure the GBI will take that position, and the DA's Association takes that position. But you beg the question when you say less likely. You know, as long as you're talking about anything other than absolute certainty, there are cases that fall through the cracks, and the innocent should never have the door closed. They should never be precluded from proving their innocence. See, once they're convicted, and the appeals are upheld, and they're serving a sentence, the burden of proof shifts. They have to prove they're not guilty, and that's as it should be, because society has spoken at that point. But the evidence that might exonerate, I'm sure that with DNA, the more that the probability is less, but it's still a probability that those things will happen.
One other question, back just briefly on the expungement issue.
Sure.
In your personal or private or professional opinion, is a person who has been deemed innocent at any point of the process, do they have a constitutional right to return to this same station?
I think absolutely they have that right. Now, you know, the district attorneys want to argue, and again, I'm not talking about Bob Keller, I'm talking about the national position that it ought to be an actual innocence standard. Well, I don't know what an actual innocence standard is. You know, does that mean that I have to prove my innocence in order to be expunged? It would seem to me that once you've had the test, once the jury has looked at you and said, not guilty, which doesn't mean innocent. It means you can't. There's not enough evidence to convict you. You should have the right to go back to where you were.
But doesn't the Constitution spell out that you are innocent
Until
proven
proved
guilty?
exactly.
And if you weren't proven guilty, then you're still constitutionally
Innocent. That's
innocent.
correct. I agree
Am
with
I
that.
misunderstanding?
No, you're exactly on target with that, and said better than I could. I think expungement is a very sore issue with me personally, and with and I can name a number of. I've got a client now who has a grandfather, and he and his grandson were going to the mall in Albany, and he made a left turn in front of a motorcycle, and was charged. And it was charged with the man didn't die, but he was charged with serious injury by vehicle. They charged him with failing to yield right away, a felony, by the way, and we retained accident reconstruction expert. We're able to establish that the motorcycle was running around 90 miles an hour in a 45 zone. And the district attorney readily declined to prosecute, but he was indicted, and he now has a record as indicted on a serious injury, on a felony. And something needs best not within the scope of this committee, I don't think, but something needs to be done to set the record straight for those who are acquitted. And it's really a relatively small percentage. And most folks are so proud to just walk away. They're not going to go. They're not going to go rock the boat and try to get the DA to agree to drop the charges. Most folks don't have a daddy that's a criminal defense lawyer.
Is that something we can address as a state, or does that indictment work its way up into some federal database that
Once
we
it
as a state
gets,
will never be able to?
I think you can address it as a state within the GCIC in the database here.
Okay.
I don't think you can address it in the federal database, and that's where, because my son was long ago expunged from the Georgia database, but he's still arrested in the federal system.
And we'll be able to ask that question later about when that goes up. Is it what point? If you can keep it from going outside the state.
He never. I mean, he was accused for less than a week. I mean, we sat down and he signed the letter that I wrote apologizing, and it was.
So when a background check is ran on your son, does that show up?
The arrest shows up today.
Still pops up.
Depends on who runs it. You see, he had to apply for some licenses, some federal securities licenses, in order to get his job. Had he applied for a job that was not that kind of sensitive, it might not have shown up. But the FBI runs those checks, and so it's a very sensitive check in his case. But it's still the same result, and his crime was he ran his mouth, which I suspect those of us who've had 18-year-old sons understand they will do that.
But if the GBI ran the check, it wouldn't show up.
I'm not sure about that. I know that in his case, when he applied to the federal licenses, the FBI ran the check. Now, I don't know. I am suspecting that. Well, I'm satisfied it's not on the GCIC computer. I'm sure that the GBI can access the federal computer. I don't have any doubts on that.
Oh, yeah. I want to ask him a question in reference to, since we were talking about the fingerprinting and the DNA, what is your association's position on the Real ID? The Real ID, the federal Real ID card,
I don't know.
This federal mandate.
I don't know that the
association
has a position. I think if you read Revelations, there's a position to be taken there. I have real problems with it on a personal level. They say we're not going to be able to buy or sell anything without a number or something. So I think it's a bad
national identification card. Really, that's what it is.
We've got there's a lot of balancing to be done well beyond this committee, and Benjamin Franklin said those who are willing to give up liberty for security are destined to have neither. And there's something to be balanced there. I want some security, but not at the cost of all my liberties. And I'm not sure exactly where to draw that line. I don't like that line drawn on a national ID card. I mean, that sounds an awful lot like Nazi Germany to me, where you get on the train and they want to see your papers. But I'm not prepared to talk about that.
Well, there's a lot of resistance from certain states, and many members of Congress are having second thoughts about it.
I
wanted to know if your association.
Well, the association has no position on it. Anything I expressed about it would be personal, and I do have some pretty strong personal feelings about it. I just think it's inappropriate. I think it's wrong. I think it flies in the face of the distrust we all had of government when we set up the Bill of Rights.
Mr. Nelson, that was my last question. I think it'll be the last. Actually, I might have two more for you, but I wanted you to speak to, not being a constitutional attorney myself or attorney at all. I wanted to have you speak to the Fourth Amendment and the kinds of things that constitute Fourth Amendment searches, just as a means of context for us as we consider things.
Fourth Amendment reads, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And the key word is unreasonable. Shall not be violated. It's an absolute prohibition against unreasonable searches and seizures. And no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be searched. That's the Fourth Amendment. And that's what the framers of the Constitution wanted protected. Without, if there's no reason for the search, if it's not reasonable, then you can't search. Now, the body of law, and some of it was discussed this morning, was plain view doctrine. You have a right, a police officer pulls me over, has a right to pull me over, I'm speeding, and observes in my car drugs or drug paraphernalia, then it's not unreasonable for him to go a little bit further. But if he just pulls me over because, in the magic word profiling, he doesn't like gray-haired attorney-looking guys riding up and down the road, and wants to look at my trunk. One of the best lines I've ever heard from somebody when he got pulled over, he looked at the officer and he said, "You're not going to look in my trunk, are you?" But in this instance, if he has no reason, no articulable suspicion, no probable cause, he can't, and no permission, he can't go looking in my trunk. He shouldn't be allowed to. But there's a whole body of Fourth Amendment law that I guess we encounter every day. I'm not sure of the specific context, but searching my house, they're pretty much going to have a warrant.
I think I understand probable cause pretty well, fairly well. Working understanding the unreasonable searches piece was what I was going to ask you about. What is that? I mean, could you crystallize that in a sentence or two as to where the dividing line is there? Because we're getting at what is a reasonable intrusion that in other contexts would be a Fourth Amendment search. What's a reasonable intrusion of someone's personal
There's a body of law about exigent circumstances. There's it's a situation, but for the emergency presented, you would need a warrant. And what is or is not an exigent circumstance justifying a warrantless search is, read the Supreme Court reports, there'll be 8 or 10 cases every year about that. But there are circumstances under which normally you would have to have a warrant to search someone's house. If the circumstances are such, if you're chasing a fleeing felon and he runs into a house, you don't have to just stop. The Constitution is a reasonable document, I believe, and it's reasonable to allow the officer to go beyond what he would normally do if it was not an exigent circumstance. Plain view. If an officer is standing, or anyone is standing where they have a right to stand, and that gets into your question about your photographs, and observe something that creates probable cause, then they need to get a warrant at that point. But if it's a circumstance that in a traffic stop, and you see the drug paraphernalia or the drugs or something that gives you probable cause to believe that, then there are circumstances under which the search can be conducted. I don't know that I could possibly draw all the lines and parameters around it because I'm not sure that they're all defined. The appellate courts redraw those lines every year. But,
what would the basis be in the context of identification cards? And again, we're going to address ID in much more detail in September. But while we have you here, I would value your opinion. What would the basis be if the standard is probable cause, exigent circumstances, what would the basis be for making folks submit to what would in essence would be a Fourth Amendment search for purposes of a ID, whether it's a fingerprint or some other mark?
The case that I handed up from U.S. Supreme Court 2004 is a High-Bell case.
Yeah.
Addresses that pretty well. In that case, they upheld a Terry type of stop in which they asked there was a statute that said that you had to identify yourself if the request was sufficiently related to the reason for the stop. And the Supreme Court said if it is sufficiently related to the stop, if you want to know someone's name and you have a reason to stop someone under the old Terry standard, articulable suspicion, then you would have to give the name. Now, you get back into I keep blaming California, and I think I'm right about that, but there's a case, the one where they said that you had to give credible evidence of who you are, and I guess that's an identity card. I don't know. It would seem to me that to require people to carry an identity card walking on the beach would be a bit absurd. But to carry a passport on an airplane going to France, I think it's a reasonable requirement. So it's a moving target, I guess, is what I'm saying to you. There are circumstances where you can be required to carry a passport. You can be required to have a driver's license when you're driving an automobile. Because and there is an offense, a traffic offense for no license on person. I've got a valid driver's license. I left it at home, and they can cite me for not having it on my person, which unfortunately happens. I haven't been stopped for that, but when I take my kids to school in the morning, I'm usually in my pajama pants and don't have my wallet with me. But those
School?
yeah.
Better watch the Sex Predator.
Yes, I got you. That's good.
Let me give you a case that you might, a scenario. A homeless person is walking down the street of Atlanta, has no ID. Stopped by an Atlanta police officer. Officer says, "Show me your ID." "I don't have any." "I'm going to take you to jail until we can prove who you are."
Well, I don't think under Georgia, I don't think there's any statute in Georgia, maybe, but I'm not aware of any statute in Georgia that would require that. Now, they might try to stretch obstruction of an officer to that degree, but I don't think it would stand.
You just look suspicious. We got to hold you until we find out who you are.
Well,
you don't have any ID on you.
Well,
this is real.
Well,
it happens.
Well, and that's why we don't trust government. That's why that's why we have these wonderful standards, and we have great district attorneys, and we have the GBI, but not everybody lives by those standards, and that's what we have to recognize, is that we're entrusting our security to people, to the government, and officers are as good and bad as lawyers are. They come in all shapes, sizes, and moral standards. What you've just described to me is an illegal detention. Now, if you had the statute that Nevada has, in which you have to give your name, which and the Supreme Court said that's not unreasonable. The officer has a reason to stop you, and that's the first question: does he have a reason to stop you, and ask you who are you, and you refuse to give up that information? Then that's a violation of that Nevada statute, which has been upheld by the Supreme Court. On the other hand, if he's just kicking poor folks around and has no reason to stop you and just ask you who you are, and you say, go eat worms, I'm not going to tell you who I am, that's constitutionally impermissible. That you cannot stop them for no reason. You have to have that articulable suspicion. If Georgia has an identification statute other than carrying a driver's license when you're driving, and that type, sort of case-specific type of thing, I'm not aware of it. It may have, and based on the Supreme Court precedent, it would not be constitutionally infirm. It would be acceptable to have such a statute, the Nevada statute, not the California statute. I would have a hard time believing that it would be constitutionally permissible to arrest someone for not having just an ID. And that's going to get into all these immigration questions and the the illegal aliens, and questions that, gosh, we never thought would be questions. But they're here, and the answers, unfortunately, are not crystal clear. Some of them seem clear, and we certainly have opinions about them, but some of them are not clear questions. I'm glad it's your job and not mine. See, I can argue with what you guys do, but you have to accept what you do. If there are no other questions,
Mr. Donaldson, I appreciate your time so much.
Thank you very much.
Albany today. We've got 1:30. Puts us about an hour ahead on our schedule, which I don't think anyone's objecting to.
No.
Is GBI prepared to talk? Or do you want to take a 10-minute break and then?
Well,
You guys want to take
Restroom break.
Let's take a 10-minute break and we'll get started at 1:45.